All right, this program is now being recorded. Thanks for everyone for joining. For those that are unable to attend and you're watching this later, thank you so much for listening in. I hope that this is an informative presentation for you. You're welcome to join us monthly on our IP, copyright and social media committee meeting calls where we have programs like this available. So please don't hesitate to join us in the future live if you're able to do so. I will go ahead and share my screen with a presentation for today. All right, I believe everyone can now see my screen. Thumbs up if you can. Perfect, thank you. All right, so this is the copyright, YouTube and copyright update for right now. It's April 2021. These things tend to change sometimes on a monthly basis. So I try to always do this program at least once a year for this committee. It's become something that's kind of fun. I enjoy doing YouTube on the side and working with creators that are on YouTube and kind of the nuances of that platform in particular. So yeah, who am I? I'm Franklin Graves. I am the chair of this committee, which is the Copyright and Social Media Committee for the ABA's IP section. I'm an in-house attorney here in Nashville. More specifically, I'm a technology counsel at a healthcare company called HCA Healthcare. And you can find me on Twitter and LinkedIn if you want to connect. I enjoy connecting with other fellow ABA members. So please don't hesitate to reach out. And if you ever want to discuss anything that we talk about here or later on, like if you want to present on something, you're more than welcome to reach out to me as well. We are happy to talk about anything related to copyright and social media. And I think I always try to strive for the practical experience element of it. So anything that you have from your practice that you think be beneficial to others, please reach out. I think it's helpful to share the knowledge and understandings of such a vast topic such as copyright and social media. So today, I always try to give a roadmap of where we're going to cover and what we're going to talk about. So today, I'm going to cover the 5 main ways for managing a copyrighted work on YouTube. And I think kind of the flip side of that too is kind of understanding if you do receive one of these, or you have a client that receives one of these, kind of where it's coming from and kind of what are some of the ways that you can respond or not respond or take next steps if you want to. So I think a great way to start and view this is as two different groupings of methods for managing copyrights on YouTube. The first group would be infringement notices, which are the DMCA Takedown notice and copyright complaint form options. Then the second group, which would be inclusive of content ID, content verification program, and copyright match, can be classified more as copyright management. As I'll highlight, the content verification program or tool can be classified as both a way to send infringement notices and also manage copyrighted works on the YouTube platform. And if I talk about, like, say, the platform or YouTube or whatever, I'm talking about YouTube, the video website. There are a lot of other products that utilize the YouTube name. So that'd be YouTube TV, YouTube Music, and some other items like that. So what we're focusing on today is like the core YouTube product, where you go watch videos either on the website, desktop web app, or on your TV, smartphone, you name it, however you access YouTube to watch videos. That's kind of the core focus today. One thing I will say before I get going, feel free, if you're live with us, feel free to interrupt me, chime in, ask questions. If I move too quickly or you want to clarify something, please. You're probably not the only one that has a question, and I don't want to move too quickly, or I don't want to forget something or not explain something. So please feel free to interrupt me at any point. This is one of the newer studies that just came out, or surveys that just came out from Pew. And I saw this early, I think it was last week I saw this, that according to a 2021 Pew survey of US adults, YouTube is the most popular social media platform. So we were talking about earlier, I don't know if this was on the recording or not, but we were talking about how YouTube is definitely considered a social media platform for a multitude of reasons. There are so many tools and features within the platform that add to the social element of watching videos and engaging with the content creators on the platform. So I know this might be a new concept to some people that are listening for the first time, but yes, YouTube is a social media platform. And in this particular graph here, definitely credit to Pew, and there's a link, and I'll circulate this slide deck too. There's a link to this if you want to go more in depth into the survey and some of the results that Pew found for pretty much all social media platforms with US adults. It obviously would be very different depending on the age grouping that you're talking about. So YouTube is the most popular according to this survey of this particular set of the population. So it might be drastically different depending on who you're talking to. You'd be talking to your friends, family, and they'll say something completely different. All right, so jumping into the DMCA Takedown portion of the presentation. As a digital service provider, YouTube allows for submissions of copyright takedown notices to be sent in accordance with what we all should be familiar with, which is 17 USC 512C. It's commonly referred to as, if you're talking about copyright or DMCA, you're talking about Section 512. Section 512 of the DMCA. So there's a lot of different terminology points used for it, but if you hear DMCA, if you hear the Copyright Act, if you hear 512, that's kind of signaling to you that this is what people are talking about. And it's the Digital Millennium Copyright Act. And YouTube refers to these as free-form copyright complaints, meaning they're not sent using a tool provided by YouTube. And as you see on the screen here, this slide shows the basic details of how to traditionally, under a statute, send a complaint to YouTube if you want to mail it, fax it, or email it. This is the current available information. You'll see there Google, if you've been following along or if you haven't updated your own personal files in a while, it is worth noting that Google's now Google LLC. Previously, you might have included Google Inc. So it's been like that for a little while, but I do like to flag that for if you have templates on your end, just make sure those get updated to reference the correct Google entity, corporate entity, which YouTube sits underneath.
This is anything on Google. Like, so if I put a song on Google and somebody copies it, if I copyright my own song, let's say, and somebody else uses it, you can go to this address basically.
So actually, this is specific to YouTube. So if it's on Google search results, there's a separate tool, a separate department, kind of division for that, mailing address. Ultimately, this information I pulled from YouTube's site. Kind of the best method of getting this information will probably be the DMCA agent directory directly with the Copyright Office itself. So if you go to copyright.gov, or I typically just do a Google search because I don't go to that directory day in and day out like some people might. But if you just do a Google search for Copyright Office DMCA agent directory. The design of the site is a little weird, but there's a way you can easily search without logging in or anything like that. You can search their directory. And so under Section 512 of the Copyright Act, the DMCA, each digital service provider, which is YouTube and any of the social media platforms that accept uploads of user-generated content, are supposed to register with the Copyright Office. Sorry, that might be a good starting point here. So they're required by statute to register with the Copyright Office.
You're right. You know what? I should have thought about that as well. Sorry, but okay.
Yeah, no, it's all good. Yeah, that's actually a good point because you're it's not like you're already familiar with that, but some people on the call might not be, or people listening later. So yeah, that's one of the important elements here to qualify for those safe harbor protections that are available to content provider or digital service providers. They have to register directly with the Copyright Office. They can't just slap a DMCA process up on their website and be deemed compliant. They might have a compliant process, but they still have to register with the Copyright Office too.
Let me go a step further. So if let's say I went to the Library of Congress, I did my copyright, all that stuff, right? Then I put it on YouTube, but those people who are trying to copy it don't know that I've already copied it, right? Now, is there some kind of infringement that would take place because of that? Is there any? So what we're talking about right now is the platform itself, the liability of the platform, and kind of getting it taken down from the platform. If you want to pursue individual users on the platform, that's a whole separate discussion. That's going to be your standard kind of infringement, kind of seeking out who those individuals would be. And that may or may not be readily visible or accessible through the platform, just the way they're designed. So to that point, I'll go ahead and say, to that point, if you are trying to do some research and get in touch with
the person that uploaded a video to YouTube that may or may not have infringing content of your client's content. One method of reaching out to them, there are a whole slew of things you can, if you want to go this route, you can comment on the video or whatever. But the best way is typically if you click on the YouTube channel that uploaded the video, the user, they have a channel. You can go to the About page on the channel, and they sometimes will include an email to contact. The reason why a lot of people do that is because they want to get contacted about sponsorship opportunities. They want to get contacted about business opportunities. So it's a way to reach out on like the business side, or just if you're a fan, you can reach out and email your favorite YouTube creator. But that's not going to be all the time. You're still dependent upon the channel owner deciding they're going to make their email address public so you can contact them. Okay. Otherwise, it can be pretty difficult to track down who owns a channel. It's kind of like the standard whack-a-mole situation with the internet that you just kind of circle back to. What we're talking about is getting it taken down from YouTube so it's no longer accessible. And then if you want to pursue anything beyond that, you certainly can try. So
there you go.
Okay. Yeah. So that's this right here. This screen right here is the most, like I said, the free form copyright complaint, as YouTube calls it. Now, YouTube has gone a step further because it's obviously one of the heavy hitters in this space, one of the early platforms and focus of copyright litigation when it comes to infringing content or allegedly infringing content. So they are really well versed and have a great process. I say great being very kind of showing my bias there. I think they have a great process, but it still can be frustrating regardless of which side you're on, having to deal with the processes that they have in place. But this is just one of them. The other one is they have a web form. So they've taken the ability to basically do the statutory process and built a web form tool that assists with the submission of what is essentially a DMCA takedown request. And it's just kind of in a pretty format made for easy submission, but then also counter on the other side, flip side of that, it also allows for easy processing by YouTube. So they don't have to do like these manual email notices or kind of whatever. They can, it's like a web form. It streamlines the data input coming from people that have copyright claims. But it's also this method of submitting a copyright complaint is tied to an existing YouTube account. So you'll need a Google account to log in and be able to access this. So it does now also, as I highlighted there, this was as of a couple of years ago now, they started requiring a timestamp for the allegedly infringing content. There, like that kind of means then a statutory DMCA takedown notice would still be sufficient without a timestamp. But if you're using the web form, it kind of triggers it as a required input before you can submit the form. And then here's a screenshot. This has changed a little bit. I did quickly log back in. There's now like a little bit more robust of a way to submit copyright complaints, both within YouTube Studio. If you have, like if you're working with a content creator or a company that already has a YouTube account and has access to something called YouTube Studio, it kind of looks a little bit different than this, but this is the gist of the kind of information. And this is, Katie, to your point, this is kind of an example of what it looks like if you have an original song that is being infringed upon on the platform. You'll be expected to indicate where the timestamp falls. And what that means is like where within the video your song or your client's song pops up and is being used. And so they have also said that copyright owners who repeatedly fail to provide accurate timestamps will be barred from the manual claiming system. That's with the content ID system we're going to talk about. So it's kind of important to maybe think through kind of your options here when you're working with clients, when you're working with companies that might be trying to send these types of complaints. You kind of have to weigh your options here. You can easily just go the path of doing a standard DMCA process, statutory process, and submit it via email and make them have to manually review it. Or you can go this path of doing the web form, playing their game, playing ball with them. It probably does end up getting a faster turnaround time. So it's just kind of a lot of different things to weigh as well when it comes to
this timestamp could come from the Library of Congress then?
Oh yeah, sorry, this timestamp relates to the video. So if you have somebody uploads a video with your client's musical song composition or whatever, or actual sound recording, whichever one it is, they upload, or both, if they upload that, I'm a YouTuber and I upload a video that has one of your client's songs on it. Mm-hmm. You can then come after me and submit this claim. And what you'll do is you'll look at the video, my video that I uploaded, and find where in the video the song was used. Because I could have uploaded a 10-minute video and your client's song only showed up in 30 seconds of it, or it could be the entire thing. Like you can see there in the screenshot, you have the option to say it's in the entire video, or so that's kind of where the timestamp comes into play. The other two options, if your client has songs that are getting illegally downloaded because people are including links to download them illegally in the video description, you would click the description button. Or if they're just links to allegedly infringing material, stuff like that, you can kind of do a little more nuance of a submission that way and not have to provide the timestamp. But if the song is in the video and that's what you're trying to claim, then you'll most likely end up having to provide a timestamp if you go the web form way.
There you go.
Right. So content verification program. This is a newer program that YouTube offers. Maybe not newer, but it's a program that YouTube offers for companies or clients or individuals that are sending a mass amount, like a lot of copyright takedown notices. And it's kind of a way to, like I was saying earlier, YouTube has become a big target on these, especially after the Viacom lawsuits. They've kind of developed a very streamlined approach. So they have a couple different options. If you have a client who has a lot of copyrighted materials and maybe doesn't have access to Content ID yet, but is still wanting to do the mass submission, it's as I've noted there in the bullet point, it's different than Content ID, but it's just one other step that YouTube offers for owners of large catalogs of copyrighted material. And then Content ID, which is I think what a lot of people are most aware of when it comes to YouTube. It is a system built and implemented by YouTube to assist copyright owners with the identification, the management, and protection of their content. So copyright owners usually are limited to those with, like I was saying earlier, large catalogs of content. So if you're just an individual creator and have released local videos, like if you're a local cinematographer and you are documentarian and you go and release documentaries and you just have like maybe 5 or 6 or maybe a dozen that you've released, you probably wouldn't be able to qualify for Content ID. You just don't have a large enough catalog, and kind of like the playing ball with bigger fish is kind of the focus for YouTube. I'm just assuming, but it's kind of most of these tools are required because on the YouTube side they don't want them to be abused. They don't want to just open it up to everyone to have access to. That's why they provide those other methods of submissions for DMCA takedowns or other copyright claims. So if you have a large catalog of content, or if you're working with a media company or something similar to that, you can register with YouTube and submit works to be digitally fingerprinted, and that process is referred to as automatic content recognition, or ACR, and it's included in the Content ID database. Once you send your files or whatever, if you have videos, if you have music, if you have publishing, it kind of applies to both all of those things: sound recording owners, music publishers, video companies. It kind of fingerprints and IDs content. That's part of what the technology does. So we as the yeah, go ahead.
Something real quick. Do you have to be a member of YouTube though in order to get the automatic content recognition information?
Yes. So to be able to upload your content to be tagged and identified based on the algorithms and everything, to where it then starts searching and checking against content that's uploaded, you do have to have a deal with YouTube. You have to negotiate with them, do all that kind of fun stuff to get access to that Content ID program. And then they give you additional tools and a specific part of the platform for Content ID.
Sorry, this is Jeff.
Interesting.
What about bootleg problems? So like one of the problems my clients have, it's live events that are bootleg. So it's not like you can submit an original to be fingerprinted because it's not supposed to be filmed. There is no original, it's a bootleg. Is that something that, how would you deal with that?
Yeah, so that's where a lot of times well, first of all, that's where I think historically the approach has been for content creators. So if they're a live performer, recording their performance, and then from that they would then, so if you're a rock band and you perform live, you would have the something maybe as simple as the audio board person recording just a rough version of the sound recording, or video, you would video it, and you would have your own unofficial version of that recording, so that you could then use it to either register at the Copyright Office or go the path of having it then plugged into these automatic content recognition systems, so that it then becomes tagged against somebody else's bootleg version of the recording. But I think ultimately the systems just are not sophisticated enough to be able to distinguish between like somebody's bootleg version they upload, unless like if it's I think the easy ones are if it's like a sound recording of an artist that's performing live and they sound very similar when they're performing live, and that just is what captures it. That's what triggers the recognition, the automatic recognition. Or if it is video, like if somebody's bootlegging a film in theaters, like we used to do back in the day, it's like those types of situations would then hopefully get triggered against the official versions that are either recorded or created later. But yeah, I think it's just an imperfect process, and it most of the time probably will not capture those instances, and it just falls down on popularity of video, or content creators or content owners doing their own searches and working with companies that can do their own searches to monitor for content outside of what the platforms themselves offer.
Yeah, it's become a game of whack-a-mole, right? Because if you take down a bootleg from one user, another user is created fake and it's up again.
Right, and then with YouTube specifically, there are a lot of issues with people uploading content that might, like, let's just take SpongeBob as an example, uploading an episode of SpongeBob, but doing so in a way where they've manipulated the video. So like they've either slightly increased the pitch of the audio, or they've made it so that the image itself doesn't look exactly right, cropping it or doing it at weird angles, stuff like that. So that they basically are reverse engineering the content recognition system, so that then it can't understand that that's the actual content that is copyrighted and is supposed to be taken down. So it's akin to a fingerprint. If you have a piece of content, it will ideally create a unique fingerprint for that piece of content, but there are ways that you can distort and make it so that fingerprint isn't an exact match. And so that's where you get into the nuances of how the platforms operate and to what degree the match shows, because you can even get down to percentage. Like this was like a 20-30% match, and are you going to do anything about it? And it then creates a manual review process. Like again, whack-a-mole, manual review. It's difficult for the content creators for sure.
So I worked on a licensing situation where we got permission to use a song in a video, and then the video gets posted. So if the song triggers the content ID, is there any type of whitelisting process, or does the triggering then go to the copyright owner, and then they'll know, of course, that you had a license and they'll say, okay. Trying to figure out.
That's an excellent, yeah. Sorry to interrupt, go ahead.
No, I was just gonna say, just in terms of building into the license, making sure that when the bot goes out and finds the song, that it doesn't get taken down, as there's not some problem when you do have a valid license.
Right, and I would say that from my experience, that is definitely one of the most commonly missed clauses or obligations to include in a license agreement on the music side, for sure, both the sound recording and the publishing license. So like for video, that would be the sync license and the master use license. And so actually, back in the fall, we had a committee call that kind of went into the nuances of that, and I'm happy to repost the PDF takeaway notes for that to revisit what that means if people aren't familiar with that. But yeah, what you're describing, the whitelisting component, is a key element of any licenses that corporations or individuals are seeking when they're working on projects. The clause that basically says you as a record label or you as a publisher are going to go ahead, and we are talking about this in advance. We are going to upload this video to this channel on YouTube, and you're going to whitelist it so it doesn't get either flagged for monetization, it doesn't get taken down, it doesn't do a copyright strike or any of those things. And so that can actually be part of what you negotiate and get. Maybe if you agree to license the song, you can say, well, this is really going to blow up on YouTube because it's a new trailer for Ryan Reynolds movie. You can negotiate, say that's going to get you tons of money from YouTube for the sound recording side of things. So maybe you can cut us a deal on the licensing, and we agree to let you run ads on it, and we won't control the ads on that video. So nuances like that are definitely part of the licensing negotiation when it comes to music. But that's a great point. I think, especially if you're doing like live streaming. So over the summer for my company, we did a live stream the last summer for COVID relief, a benefit for all of the nurses across all of our hospitals. And we had all these people that were performing their songs, country music artists, all that kind of stuff. But what we had to do was like, we were doing it on Facebook. So I had to get in touch with contacts I have at Facebook, and then also the record labels to like do exactly what you're talking about, whitelisting, to make sure that it doesn't get taken down. Because like we had one shot at this. We were only doing a live stream, and it was only going to be up for, I think, 24 or 48 hours. And so we couldn't take the chance of having the content taken down. And unfortunately, it got taken down for a couple hours, and then we got it put back up. But it is one of those situations where you can try your best to whitelist and get ahead of what you might think the content platforms are going to do automatically. And then there's still some bug along the way that you might forgot to click a button. But that's definitely just comes along with the territory when you're dealing with a huge amount of clearance work. But really, really excellent point. And that ties in directly with this content ID discussion. All right. I think I'll go ahead and keep going. So I mentioned earlier on, if you are working with creators on the creator side, making sure that you understand how you can help them when they receive these types of notices as well. And so if it comes from content ID, and kind of what I'd say is like on the front end burden that is placed on content owners to map out the timestamp of where your song appears, kind of is a helpful benefit for creators that are uploading to the platform on YouTube, because they have the option. YouTube now has built-in tools. Like I said, YouTube is very robust in their tools that they've developed and built for creators, for their content creators on their platform. So if I upload a video and if I get a claim, and because I used a music track that I thought I had licensed, and for whatever reason I don't have the license for it, then I can go in and mute that timestamp segment. It's not ideal because a lot of times it might be just background music, or if I'm talking over it, it might be difficult to do. But you can also, YouTube can do an algorithm replacement of the song. So it might be a little weird if you're talking over it or not, or you can just completely cut the segment from the video. And I highlight these because up until a couple of years ago, if you represented a YouTube creator and they received these takedown notices or they received these kind of claims, YouTube still does not allow videos to be edited once they're uploaded. You can't swap out a new version of the video once you've uploaded it. You have to delete the whole video, which means as a content creator, you lose, or as a business, if it's like a very viral video, you lose the momentum on that video that you had gained. So you have to take the whole thing down and re-upload it and start from scratch. 0 views, 0 likes, 0 comments, all of that. So the fact that YouTube is working and kind of listened, if you will, to the needs of creators in this space, I would say it's been a benefit and kind of part of the elements of that. Oh, got a hand raised. Sorry, I can't see your name, but yeah, go ahead.
Sorry, I was trying to figure this out on my computer, and once again there were other problems. But sorry if I missed the point. Why exactly like does YouTube not allow multiple versions of or improved versions of the same, I guess, similar content?
Yeah, that's $1 million question. I think I think it's just their platform policy. Once you upload a video, it's kind of nice because once a video is uploaded, it becomes viral. It can't be changed. Everyone from the point of uploading and going forward is watching the same viral video. So it's kind of like on Twitter, you can't edit your tweets, or on Facebook. Well, Facebook you can edit, but on Twitter you can't edit your tweets as of right now. So you basically see people adding on like a new tweet that says, "Oh, this tweet blew up. Here's a GoFundMe," or "Here, support this cause." Like, I think there's just an inherent kind of, I don't even know what to describe it as, but to me, I think it just, I don't know YouTube and their policies, but to me, it kind of seems just from a platform policy perspective, it would be a dangerous game to let people change videos as they go along.
Yeah. So like, do you see that more as like sort of a protection for the viewers and stuff, like especially if they comment and one video turns into something completely different that's like a hate message, you don't have these comments saying, yeah, like we support you. Like
there probably is that element to it of preserving the original conversation that was happening around the video as it has stood the entire time. It preserves the awareness and kind of the context for other viewers later on when they see comments talking about something. And I think to your point, I think it preserves the integrity of the video, so that if a creator uploads something and it becomes a viral success, like David After the Dentist, they can't just go and add on like a 10 years later update and like completely kind of ruin the originality of the original kind of thing. So
cool.
But yeah, I think there is that element of it that's frustrating, because there have been times like I upload a video to my YouTube channel and it's like there's a drop frame, or I forgot to like put an asset in there that like needs to be in there. I forgot to talk about something. You can't go back and do that. You have to delete and start over. So not that I've had the viral video issue. I could easily delete it. Nobody would care, but just an example.
Awesome.
Yeah, great question.
Thank you.
Yeah. And if your clients ever receive something about content ID claims, this is kind of what they can expect, or what you can expect would be in it. This one's for music specifically. And about a couple of years ago, I say new tool, but it's not new anymore. YouTube launched the copyright match tool, and it's offered to YouTubers. It still requires acceptance into the YouTube Partner Program, although I have seen where you can apply, even if you're not part of the YouTube Partner Program, you can still apply as just a regular YouTube uploader to get access to it. You're most likely not going to get it. I haven't seen it. I haven't heard of people that I connect with that have actually gotten it. But if you're not familiar with the YouTube Partner Program requires a channel with all these different like kind of watch statistics. Basically, kind of, again, YouTube has so many content creators. They only have a limited support staff. They want to offer dedicated support and resources and tools to the kind of the most popular, if you will. That's just kind of how it is. The successful creators on their platform. So you have to like reach a certain amount of watch hours on your video. You have to have at least 1,000 subscribers, and then you also have to have connected a monetization on your account, and that means connecting to Google's other product and platform called AdSense, to where you can get ad revenue payouts. So there are a couple of different distinctions about what it means to be a YouTube partner and different levels within that. And you kind of get fun creator buttons, all this kind of fun stuff that comes along with being a successful creator on YouTube. But copyright match is one of those things. And the best way that I think about describing content match or copyright match is that it gives the creators on YouTube the option to protect their videos as they upload to YouTube. And so kind of going back to the conversation we were having earlier about YouTube essentially gatekeeping access to Content ID. You can't just go and be a part of the Content ID program and start protecting you or your client's works. This is another option, is if you reach certain thresholds again, but if you're part of the copyright match program, you can at least have your clients or your own content protected in a way and take actions. A lot of this stems from re-uploads that were happening for a lot of content creators on YouTube. Basically, once successful creators were starting to upload videos that were getting millions or hundreds of thousands or millions of views, they started noticing other people were copying them, downloading them, and re-uploading them or doing stuff with them. And so this is all within the YouTube platform. And so when you upload a video to your YouTube channel, it can automatically start getting matched from that point forward against any content uploaded to the platform. So if somebody's stealing your content or re-uploading it, you can take certain actions. Your client can take certain actions. And so I did put together some charts to kind of break down the differences between some of these different concepts and tools that we've been talking about with YouTube. For the sake of time, I will not run through them in full. But again, this will be posted and shared. The PDF slide deck will be posted and shared later for those that would like to have it. And then this one's again showing the differences between DMCA, which is statutorily created, and Content ID, which is YouTube's own system built upon and mirroring kind of some of the statutory options. All right, and so I always like to provide kind of resources that I use to stay up to date. So the official YouTube blog and the YouTube creator blog are kind of some helpful resources that I subscribe to and get to my inbox. And then TubeFilter and Adweek are two kind of industry news resources that are helpful. And then VidCon. Historically, VidCon has been kind of this, in Anaheim, California, this kind of go-to event where you have this mashup, it's wild, this mashup of YouTube creators and like these tween and teen and young adult followings that like fans that go there to meet and greet. And that's all happening on the first level of the convention center. Then on the second level of the convention center, it's like this educational session, kind of sessions, kind of conference sessions for speakers and stuff to listen. So if you're a YouTube creator, you can pay a little more and go to that level of it and kind of learn how to grow and build your business on YouTube. And then the third floor was for industry insiders and kind of so like Amazon. When I went a couple of years ago, Amazon was like launching their merch business. So they were trying to target creators. And so they had a whole section there for industry people that were basically, they wanted to connect and provide merch for people to sell through their channels. So VidCon's great. It's obviously changed a lot. So there's all that to it, but it's still a pretty good resource. I use it mostly just to stay in touch and attuned to all these young creators and kind of who these people are in the industry, because I get lost with how many creators there are these days. So yeah, my email is also franklingraves@gmail.com, but either one. But happy to answer any questions if there are any. Oh, sorry, I did not see the chat, but it looks like some people had to drop and wanted to copy the PowerPoint presentation. So yeah, definitely we'll do all that. And yes, the CASE Act is definitely important and going to be a huge impact. So thank you, Alicia, for sharing that, because that will be a huge impact on all of this as well. That's basically the creation of the Small Claims Copyright Board. I don't know the official name for it yet, but either way. All right, if there aren't any other questions, I will go ahead and stop the recording.